right, get ready for a fireside chat where the speakers will be talking about the importance of having a robust intellectual property strategy and how to protect yourselves against infringement by competitors. They'll also discuss what to do if someone infringes on your IP rights, including when it's worth suing or when it makes more sense to just settle out of court. All right, the speakers for this fireside chat: Mr. YeongBoon Ooi, Managing Director at Exy Intellectual Property. Welcome back, sir. Shaina Jones Magrone, Founder and Managing Attorney for Artisan Law. Hello. And Vaishvi Khare, Director at Vidhinyas Solicitors and Associates. So you will have 35 minutes and the last 5-10 minutes for questions from the audience. Thank you.
Well, good afternoon, everyone. Thank you all for joining us today. You know, I'm such a loud person, I can't believe that you couldn't hear me. So good afternoon, everyone. We want to thank you so much for joining us here today. As you know, my name is Shaina Jones Magrone. I am the founder and managing attorney of Artisan Law, based in New York City. So happy to be here in this lovely city of Dubai. You know, we really want to, I think we should all introduce ourselves, but we really want to do something different and have a real chat discussion with you. Because intellectual property, to the extent that you know about it, can be very amorphous, right? We want to make sure you understand some basics as we go into our topic. So, you know, if we could all just introduce ourselves so that everyone is familiar with who we are. So.
Okay. Hello, everyone. I'm Vaishvi Khare and a director at Vidhinyas Solicitors and Associates. So we are currently based in Mumbai, India, and we deal in the matters related to corporate law, media and entertainment, data privacy, and IP.
Hi. My name is YeongBoon. I'm from Malaysia. So we primarily specialize intellectual property in Malaysia and Singapore. So as he mentioned, intellectual property is a topic of discussion for a while now, to be very honest. Even in Malaysia by itself, the law has been established for almost 50 to 60 years. But the issue is, until today, intellectual property law is still a wide topic of discussion up to today.
So my law firm works in a couple of sectors. We work in intellectual property and business law, as well as in estate planning, helping with brand protection as well as asset protection. And I would love for us as a panel to really just set the tone for understanding what we're talking about when we're dealing with intellectual property. You know, we're really dealing with three major areas, you know, patents, copyright, as well as trademark. And when you think about brand protection, you often think about that trademark portion of it. That's what often comes to mind. It does, however, encompass all of that. And of course, there's trade dress as well. So I wonder if my esteemed colleagues can just talk a little bit about, you know, how you work with your clients in those major areas and what you see with them in those areas.
Well, we have a lot of clients in our firm. Primarily, they are SMEs, right? They are like startups, so on and so forth. So, in a lot of them, even law firms, to be very honest, when you want to start a business, typically you either get yourself registered with the what they call company commissions, or even law firm, you get yourself registered with the bar council, so on and so forth. But people don't remember. When you do business, people know your brand as the business. People do not know your company as the business. So that's why, for example, a brand name, essentially we call it trademark. That's why the term trademark. It's a trading brands for you to be in the market. So essentially, a lot of times we have a lot of like startup, SMEs, so on and so forth. Whenever they come to us, they will always ask us this question: Why? Why do we want to file for a trademark? Why do we want to spend this kind of money? Might as well I spend that money on marketing. Might as well I spend that money to do some investment to grow my business. So the issue in hand, people do not understand the importance of brand name. For example, about 6 to 7 years ago, I'm not sure whether you heard of this. Chanel. Chanel is a huge brand, right? Chanel is a huge brand, right? Ladies, I'm sure you know the brand Chanel, right? So what happened was, Chanel wanted to enter into Indonesian market, right? So they have a contract with a very well established a mall, a very well established mall in Indonesia. So what happened was when Chanel wanted to enter into Indonesian market, the attorney over there made one mistake. They got the company registered in Indonesia, but they did not get their brand registered in Indonesia. So what happened was, Chanel, obviously being a big brand, they wanted to sue. Right, they wanted to sue the IP squatters. Someone actually filed for that trademark in Indonesia. However, the problem is Chanel has an existing contract with the mall. So time is of the essence. Right? Chanel don't have a choice. They settle out of court for about almost 10 million US dollar. Right? So the thing is, brand protection is something that a lot of business owners today, right, is never something that they will put it as a forefront, as something that they will spend money on at the onset.
I think YeongBoon makes a great point. I mean, several great points. You know, one of the foundational things that I know we each have to deal with our clients is making sure that they even have taken the steps for registration, whether it's trademark, copyright, patent. You know, patent folks can tend to be really quick to get to the office. But our trademark and copyright clients can be a little bit slow, right? Dealing with whether or not they want to make that investment, or even understanding how important it is to them, both for the registration with the office as well as their domain name registration and what the issues can come about with that. What have you seen?
You guys are absolutely correct. We have a client from a startup background, music label, production houses. So there are so many people who actually understand why we should, register our IPs. And there are some clients who do not understand, like, what is the importance of, registering your trademark, even your copyright work, etc. So we really suggest our clients to, register your IP so that you can protect your brand's identity and reputation of your company, which is really important because it takes 20 or more years to build your reputation or goodwill of your company, and it will just take 5 minutes to ruin it.
It's an excellent point. You know, in the United States, we have a very well ingrained history of intellectual property rights as well as intellectual property protection. Copyright as well as patent rights are built into our Constitution. We have congressional acts to address trademark. But even with that, it can still be a difficult undertaking in order to get your clients to move forward. And then once you do get them to move forward and you register, you have the all-important task of having them understand the importance of monitoring their brand for infringement. Many of you may not know this, but the onus is really upon the brand holder to do all of the work from monitoring whether or not their brand has been infringed upon. And it kind of makes sense, doesn't it? You know, you own it, you protect it. So I wonder if we could talk about some of the stories that we've seen, infringement cases maybe you've seen, lessons you've given to your clients.
Well, my client always asks me this question. I spend so much money paying your firm. We have gotten the trademark registered. We have gotten the IP registered. Why is someone else infringing my mark? So that is something very commonly asked. I'm not sure whether your client asks you that question, but I always get that question. They'll be like, I already got it registered. Why is someone else using it? So the thing is, as mentioned, you own the brand, right? You own the brand. it's your duty of care to get it actually properly maintained, properly watched, and monitor to make sure whether any third party actually infringe on your rights. It's like owning your house, right? I'm not sure about other countries, but in Malaysia, we like to build fences, right? We like to build fences so that people don't just randomly walk into our houses, right? So it's like owning a house, right? If you protect it, it's your job to make sure people don't trespass, right? You cannot be expecting once you get it filed, it stops there. And the best example is always the digital space, right? With the current era, the digital space is huge, right? It's basically borderless, right? So sometimes imagine this, right? You are, for example, a UAE company, right? You own a brand, you get it registered. But the moment you go online, the moment you put your business online, cross-border happen. When cross-border happen, how do you get yourself protected? How do you stop a third party from infringing? It's a tough question. It's a tough strategy. It's very, very hard. It's very, very costly for you to actually get your brand protected everywhere. But the thing is this, once you go online, once you go into the digital space, it's your job as well to basically find a strategy to get yourself protected and make sure people don't come into your house.
So, yeah. So there are so many clients who will obviously register the trademark, and then they do not want any services like, for a watch services, journals, watch services. And there was one client who actually copied the whole trademark and then asked me why people are coming after me and all that. So I always suggest that you should always seek a consultation from a lawyer, not from a CA or something who do not have the knowledge over the legalities and everything.
So my law firm works very heavily with clients in the fields of cosmetics, fashion, and tech. And when companies come to me, they will come to me in the startup phase, but oftentimes I will also have clients for whom I do an IP audit for. And I'm going to say that at both stages, I will see some of the same things, right? There's generally a lack of strategy. If they have filed, where are they going to look to do their protection? Who's going to do their monitoring? And what's going to be the budget in order to do that? So for any of you who have clients, I think a lot of this talk is about how can we also help our colleagues to understand how to identify these issues for their clients, either refer them to other counsel or just give them some words of wisdom about how to move forward. So you really need to address your clients and talk with them about what's going to be the budget. How robust can they be with their monitoring? Who's going to be in charge of looking at what the standards are of how their brands are addressed in the online sphere? Who's going to make sure that their handles are properly protected and properly maintained in the international sphere? And if they are going to be international, as YeongBoon said, who's going to be in charge of that monitoring overseas, making sure that they are appropriately registered with whatever international protocol they may be addressing in whatever part of the world they are? It's important to take the time to make sure that your clients are properly counseled and moving forward in that direction, because for many companies, intellectual property is the largest portion of their revenue. It's the most important part of their business. I know in the United States, IP is one of the highest, if not the highest, product that we export. It's extremely important in the national and international sphere. So I wonder if you all could talk about any horror stories you may have seen, or how you help the client to move out of a horror story that you've seen. I know we've all got some, guys.
We have client, that we actually do not look into the litigation sector, but yeah, we have clients who actually copy the trademark and come to us related to it. Yeah. So,
Well, a horror story. Definitely, we have horror story when when we're in the legal industry. You see, right? So, for example, in Malaysia, we have about 70% of our population are majority Muslim. 70% of them are Muslim, right? In Malaysia. So for those Muslim society, what happened is they are very in Malaysian market example, they are very keen in terms of certain level of cosmetic products, right? So the thing is, when it comes to all these different cosmetic products in Malaysia, right? Their price point are typically very, very cheap. For example, it can be as low as $10 to $15. So a lot of time they actually use their brand to sell, right? So because of that, their sales in a month can go up to $1 million. So imagine how much transaction it actually goes on. So because of that, in Malaysia, very, very commonly for this industry, there are a lot of IP squatters. So a lot of those not honest traders, what will happen is they will typically go and file for all these trademarks, and then after they reproduce all these cosmetic products. I'm sure in other countries, even in Malaysia, OEM for cosmetic products are very, very common, right? So what happened is they will OEM all these products and then they start selling at a much more cheaper rate, and of course the quality is much more worse than the original product. So we conduct a lot of raiding cases with the Ministry of Domestic Trade. We conduct like private raids or even private investigations, so on and so forth. So when we do all this raiding or even private investigations, so on and so forth, you'll be surprised the amount of what do you call violence that this infringer actually put forth when the raids actually happen. So protecting IPs is not something. It's not about protecting it as well. It's about to protect your business, because IP is your business. So business owner need to understand that without your brand, without your IPs, you don't have a business.
also, in today's world, we all know everything is digital right now. So there are so many people who actually build a similar websites. They do cyber squatting, they do typo squatting, they'll claim your URLs, similar URLs. They'll do, there's so many different of brand abuses such as counterfeit products. They'll make exactly your product with your exactly logo. Uh, there is so much piracy in the copyright sector as well.
And so I think when we see clients and clients see individuals abusing their rights, abusing their marks, one of the main things that I know I have to, and I know my colleagues do as well, we have to counsel our clients on when it makes sense to go forward and what it makes sense to do, right? So if you are not aware, IP litigation in general is often going to be a very expensive affair. And so clients have to really have an understanding as to whether or not they have the stomach to go all of the way. So oftentimes addressing an infringement can really be a step-by-step process to see how far your client can go. I know oftentimes for my clients, we'll start with an infringement letter to someone. You know, it's a scary letter you send out to someone, you say, you're using my stuff, don't use it anymore, otherwise we're going to court. And oftentimes that will be enough to scare somebody away. Because what you may not know is that most infringers are never confronted about the process. But then once they are confronted, they know they're seen, they often understand what the consequences may be. And that may be enough to push someone off. Then after infringement, you may have to go further and then further move into the litigation space. But I wonder if my colleagues could talk about some of the steps that they take in working with their clients in addressing a potential infringement or an actual infringement.
Well, to be very honest, if I may add on, typically sending a cease and desist, a warning letter to the infringer are something very common. But a lot of time, clients or even business owners, they don't understand one thing. If the infringer, they have the firepower in terms of money to go through the litigation process with you, they may actually destroy your brand. They may actually take your brands away. So the thing is, it depends on country to country basis, right? Certain country, they follow first to use system. Certain countries, they follow first to file system. So it really, really depends case to case basis. We do have clients, they are in a certain jurisdiction whereby first to file system. But in Malaysia itself, they are the first to use, right? So in Malaysia, we follow first to use system, right? I think in US, you follow first to file, right? Or first to use?
It depends upon.
Okay.
It depends.
Yeah. So it really depends on countries to countries basis. So our clients, right? They have their mark registered in Malaysia. They spend a lot of money in filing them, what they call in promoting their brands and get a very good valuation and goodwill eventually. However, when they want to enter into another market, when they enter into a first to file system market, some of them they don't even file it first. Some of them they actually use it first before they file. So this is something that the client need to understand, which jurisdiction you enter, so on and so forth. Even so, sometimes it's not about, we have to understand one thing. As a business owner, what you want is you want worry-free, right? What you want is when you enter into market, you don't want to have any problems. You don't want to have any issues. You don't want to consider, can I enter into this market? Can I not enter into this market? So that's something very, very important for us to consult our client and ask our clients, what's your strategy? What's your export strategy? What do you plan to expand your business, or do you plan to stay within the local market?
So for me, I always suggest my client to settle out of court because it is obviously much more cheaper than litigation. Litigation will always drain the clients. But obviously, as you said, it depends on case to case. If you are a prior user, so in India, we also follow the first to use basics. So yeah, if you are a prior user, then you can obviously go and, sue the client if you have an upper hand over that matter. But yeah, it's much more better and efficient way to settle the matter out of the court.
So I agree with with Vaishvi. I find that it works better for the clients to settle out of court. I find that for many matters. I have been, prior to becoming an IP and estate planning attorney, I was a trial attorney for the first part of my career. And I think one of the best things that I received in that training was an understanding of how to spot issues that are going to bring you into litigation, and then how to try to walk you back or provide the protection in advance. And what I often find for clients is that trying to find a settlement out of court is often going to do the most for them in terms of their peace of mind, in terms of their pocketbook, and also in terms of coming to an understanding of really what the importance is of having that strategy in advance, right? It's really a lesson in understanding how to proactively move your brand and your company forward. Once you have a situation where you've dealt with an infringer one time, you do things much differently from a corporate and a brand perspective. And so I wonder, for my colleagues, before we get into some Q&A, hopefully you guys have some great questions, if there are any, specific strategy points that you give to clients, that you often find yourselves giving the clients over and over, that you think helps them move forward.
Well, I always, whenever a client comes to me, other than advising them in terms of protection in the local jurisdiction, obviously, I always ask them, what's your next strategy? Do you plan to export? Why do I always ask that? Because there are certain jurisdictions that very, very commonly that I tell my client to look into. For example, Indonesia, Australia, even China. Those jurisdictions are a very common jurisdiction where IP squatters actually exist. For example, I'm not sure, have you all been to Australia? If you actually been to Australia, you will never actually see Burger King in Australia. So in Australia, Burger King is actually called Hungry Jack, right? So why? IP squatters issue, right? So it just doesn't make sense for Burger King to settle it or even buy the IP over. So very often I ask my client this question, what's your export strategy? So once we know the export strategy, there are a few methods in doing it. For example, there's some international protocol, we call it the merit protocol, right? We can go through that for a cheaper option for our client, right? Or we can go through a conventional method whereby we file in different jurisdictions to help our client to protect their rights. So very, very often, I always ask my client this question, what is your strategy? Do you have an export plan? Do you have a export strategy other than the local market?
Okay. So in my opinion, everyone should, everyone should register all their IPs, as it is a great asset to your company. And also hire a professional who will guide you and who will monitor and protect the brand's identity and reputation of your firm and the company. As it will obviously prevent the loss of consumer trust and losses, and it will obviously safeguard your name and the reputation of your firm. So yeah, I think you should obviously take the advice from a professional who will give you in a more better way. So, yeah.
And I will just add on to what my colleague said, particularly Vaishvi, in terms of the registration. So in the United States, particularly for trademark, you do actually have to use the mark in order to receive the rights. We have a system where you can actually file as a mark holder where you are actually in use. We also have an intent to use system, right, where you can indicate that I do intend to use this. I do intend to put it into the marketplace. I'm not quite there yet, but I want to protect those rights. And so part of the strategy is looking at what your marks are, what you're going to use them for, and then you can plan out at what time it makes sense in order to go forward with that protection and that use, right? It is important, of course, to look at what your export strategy is if you actually do have one, right? So you can plan out what of the protocols you want to use. There are various regions around the world that have, we call them protocols. They have cooperation systems for trademark registration. The Madrid Protocol being the largest international body for the registration of trademark across the world, right? Affecting many of the European countries. There are also some localized protocols. There are those in certain areas of Africa, certain regions of Africa, certain regions in Asia. And then there are some also additional individualized protocols across various states that may not participate in others. But you, of course, have to look at what you're going to be doing in the future so you can have that plan for when it makes sense to do what. If your name is already taken someplace, and if you need some form of a coexistence agreement, or if you just have to register as something else, right? So I want to give my colleagues the opportunity to give, any closing thoughts they may have, and of course, take some of your questions.
Yeah. The one statement that I always tell my client would be, protect your brand is not because you want the protection. Protect your brand for your business.
That's true, actually. Protect your brand. Obviously, register all your IPs again. That is the one of the most and important asset for your company. That's true.
So I would say that, brand protection is really about peace of mind. It's about making sure that all of the hard work, effort, resources that you've put into building what you're building is really going to be there for you when you need it the most. IP protection will give you that. So with that being said, we'd love to answer any questions that you all may have.
You said that it's good to settle out of court. My question to you would be, when do you advise that it's worth the fight?
When do you advise what? I'm sorry?
That you should fight. Because we do talk about brand protection, trademark protection and everything. But when would you say that you should fight to protect, and what format of fight would you recommend?
Well, to be very honest, it's a business decision whether you choose to fight for your brand or not. Because ultimately, when you go for a litigation process, it's very, very costly, right? Sometimes when you were to decide to expand your business, you only have a limited amount of fund, right? So you have to make a decision. With that fund in place, do you have enough fund to fight for your brand? Or do you want to use that fund to actually build that business in that particular jurisdiction? So we cannot advise our client when to fight or when not to fight. I mean, let's be honest. Anyone on the floor as lawyers, we will definitely ask our clients to fight. That's where our fee comes, right? But the thing is, we are not in that position to advise our client whether to fight or not. Why? Because ultimately, it's a business decision.
I think some of the things that, you can look at in making a determination about whether to go to litigation over your IP is, how deeply entrenched are you in the market? How much capital have you expended in order to build that brand? Have you gone into production already? Are you already in markets, right? Are you already registered in one class? So for example, in the United States and abroad, right, you have to actually register your trademark in a particular class. You have to show that you're using it for this particular thing. So are you deeply entrenched in that class? Is it a class that you're really, really, really trying to move into? Or can you really step back and move on to something else, right? A lot of this, I'm going to say, can be alleviated in the filing process. I really do think it's so important to stress to your clients that, doing that work on the front end is often going to save you a lot of heartache on the back end. So have you worked with someone to do a very comprehensive search to see what's already going on in the landscape with your potential brand, right? So you cut off litigation at the pass. All right. Anyone else? Anyone else?
Thank you. Sorry, regarding the last point that you just mentioned, protecting the trademark or whatsoever, it depends actually on the category actually you are, registering or filing, starting from the search till the end actually of the protection. So the question here, sometimes non-registering in certain classes may create a confusion if somebody else steps in and use that brand in different category. So what's your advice for that based on what you just mentioned? And if there is a previous use actually of certain trademark without registration, to which extent that will help in protecting the trademark if somebody else steps in and register that before the original owner, register it? Thank you.
That's a great question. So, there's a couple of things. I think one of the most amazing things about the trademark system, and particularly the trademark system in the US, is that simply because you're registered in one class doesn't mean that you're precluded from registering that same brand in another, right? I don't know if you've ever heard the phrase that there is nothing new under the sun. But the truth of the matter is that many of the thoughts and ideas that we may have for a brand name, someone has likely thought about it before, and they may have used it in a different context. So simply because someone is registered in one class doesn't necessarily preclude you. You may have an issue depending upon perhaps how closely related those classes or categories are about moving forward. But there are persuasive arguments that can be made. So there's a cost-benefit analysis of looking at, if you have a brand or you're looking to register a brand that someone is already using in another class, how closely related is it? What are the arguments that you can make to differentiate yourself from that other brand? And also, even before going forward, you have to make a strategic decision as to whether or not you want to engage the other party to perhaps engage in a coexistence agreement. All of those are strategic decisions. Now, as to the second part of your question, you know, you have to, or a client has to make the decision fairly early on about what it's going to be worth to fight for that particular brand. What does it really mean to them, right? We have in the US what's called common law trademark rights. So, of course, we are a system where you need to use it and you need to file for it in order to get that high level of federal protection. But there are also people who never file, and these people may find a brand that's already using their mark and they've filed with the office. They may still have some common law rights. That's going to be a particular case in the US where you may have to engage in a coexistence agreement. Often that common law mark will have its rights in its particular region, often its particular state, and that federally registered mark that may have come later will have rights across the rest of the country.
The World Intellectual Property Organization, they have basically divided trademark applications into 45 different classes. In particular, class 1 to 34 is for products, 35 to 45 is for services. Example, class 20 is for furnitures, class 1 is for chemical products, so on and so forth. So one of the key area business owner, even applicants need to understand that when you file for a trademark, it's very important for us to identify the classes that you are in, right? So if you want to monopolize the whole industry, it will never happen. It will never ever happen. In Malaysia, many years ago, I think about 10 years ago, there was a case between McDonald's and McCurry, right? So McDonald's basically sued this Malay restaurant called McCurry, McCurry. So what happened was McDonald's actually lost the case. So McDonald's being in such a big corporation, obviously they will file for all 45 different classes. However, there are a lot of people, they ask the same question. McDonald's, they are restaurants, they are in the food industry. So obviously they'll be the same, they will file in the same class as McCurry as well, being a Malay serving restaurant. However, McDonald's actually lost the case. Why McDonald's lost the case? The court decision was McDonald's primarily, their target audience are people who dine in for fast food. They will go to McDonald's for fries, they'll go to McDonald's for burgers. However, for McCurry, their target audience are very, very different. Their target audience are audiences that go in there to have curry dishes, to have rice. So even you were to try to protect yourself in various classes, so on and so forth. Every single brand, every single industry, you have a distinction point in your business. So ultimately, the important part would be getting the right attorney, getting the right IP lawyer to help you when time matters.
I think that's why comprehensive search is very important, but people don't get it. They just go and just register themselves or, through a lawyer.
Thank you.
All right, we want to thank you all so much for your time. It's been a pleasure speaking with you today.
Thank you, everyone. Enjoy your evening.
Thank you very much, panelists. That was a fantastic synergy amongst you. Thank you.